Will Smith, a good neighbor and an actor. Yes, Will Smith lived in Reisterstown for a while, and a good idea for everyone. Will planning is a good idea for everyone. Um, and I want to use the old phrase that failure to plan is a plan. It's just not a good one when you're doing a will. Good estate planning looks at everything that you're doing and everything that you have in items such as your real estate, your accounts, items outside that you want to account for, but perhaps shouldn't go through your will. There's things like life insurance, pensions, and other funds that if you can take them and keep them so they don't go through your will, it makes sense. And that's important, and that's why we do this. I tell people about a story. A friend of mine got married about a dozen years or so ago for a second time. And after a decade, the spouse passed. And when the friend looked for a will, there was a will, and it found pretty much everything was left to the spouse. What hadn't been accounted for was prior to being married, the spouse had set up a pension, and the pension was left to the children. And so my friend was very surprised to find out that the significant asset in the estate, that being the pension, wasn't going to my friend, it went to the spouse's children. It was probably not done in any way to cut the spouse out of the friend out of the estate. It was probably done because nobody thought to ask the question after they got married, hey, what are we doing with our will? What are we doing with our estate? And that's why you need to look at it. I tell people, and all of us on this call are young enough that we ought to be thinking about doing wills, but understanding that we're going to redo them once, twice, maybe 3 times more in our lifetime as conditions change. Your will should look one way when you have young children or children under 18. They look a different way when you have children that are entering the workforce and you're getting ready to leave the workforce. And they'll look a totally different way when you have retired and you're ready to make some changes in how your estate looks, and you have children and grandchildren, some of whom already have significant assets of their own. And so a will is not a static document, except it's static at the time of death, which means you can change it up until death, and I encourage people to do that. Now, the important thing about wills that people need to understand is there's 2 primary goals for a will. The first is we want to let people know who gets what. You get to direct how your assets are distributed. Who gets the pension? What happens to the life insurance benefits? Who gets the house? Who gets the other assets within the house? Grandma's antique collection of thimbles. Who gets them? That sort of thing. The second thing, and people forget about this when they're doing estate planning, but is absolutely appropriate and is legal, is we want to do estate planning that minimizes any share going to what I'm going to say generally as the government, the federal government, the state government, any government. Now, over the years, taxes for estates have gone down, and they are now less than they used to be at times, but you still want to minimize any share of that going to the government, because as much as we love our country and we love our governments, maybe, we insist that we want to minimize what we pay to them, and that's perfectly legal. So you have those 2 goals: who gets what, and the second goal of minimizing any share that goes to the government. What happens if you don't have a plan, if you don't have a will? Then things go by what we call intestate succession. It goes according to the laws of Maryland. Typically, it doesn't go to the local school board except if there's just no one else available. But what happens is it goes to the people that are most closely related to you, and that may be exactly who you want to get everything, but it may not. You may have 3 or 4 children, and 2 or 3 of them may be totally independent and financially secure, and the 4th child is either too young or perhaps for whatever reason is not financially secure, and you want to direct some of your assets to your first 3 children, but you want to give a little bit of it to your fourth child and say, I want you to get the lion's share because you need it. And you can do that a couple different ways. You can give it outright as a gift to that child that they keep forever. You can also set it up as a trust or a holding that would be used for that child. And then if that child reaches certain age or abilities, you end it and you split it among all your children. It's just one way to do it. If you don't have a will, none of that happens. It just goes according to the laws to your closest relatives, usually in equal shares. I want to spend a couple of minutes talking about the different estate documents, and then really I want to answer your questions. When we're talking about estates, there are really 4 different documents. There's a will, there's a power of attorney, there's a medical power of attorney, and then there's what I call the right to die declaration, or we call, in what I think is one of the worst names ever, the living will. Each one of those do different things. You really can't mix them together because you can't put a living will into a regular will. A power of attorney is markedly different than a medical power of attorney. Some of these are mandated in style and format by state law, and most attorneys, myself included, will pretty closely follow that. But they're different, and so let's talk about them. The simplest one is the will, what we all think of. We have beneficiaries in a will. That's who gets what. Initially, if you're married, your spouse doesn't have her or his own estate, you're going to leave everything to the spouse, with the exception of perhaps some minor gifts that you want to give directly. Your wedding band you may want to give to your oldest son. Your gun collection you may want to leave to your daughter. These are specific gifts that you can give out, but at least when you're young and you don't have a lot of assets, you want to make sure that your spouse is provided for, and so you may leave everything to your spouse. Those people are the beneficiaries. They don't have to be relatives. You can make donations. It's going to make Kathleen happy. You can make a donation to your local chamber of commerce should you choose to. Yep, there she goes. It can be, and more commonly, you make them to your religious institution, your church, your temple, your whatever group that you want to leave it to, and you can do that. Yes, you can make a trust for your dog or your cat. People do that also, but they're the people that we leave things to, the beneficiaries of your estate, the people that are going to get them. The other 2 characters that we talk about, one is the trustee. And I talked before about if you have a child who perhaps has some special needs. Maybe it's just a young child, a child that's 5 or 10 and not ready to handle money. You leave that money for the child in trust, and you tell your trustee to spend the money on behalf of your child for things they need, such as education, such as health care, such as household needs. And the trustee is the person that does that. You can have trustees of any nature. Your local banking institution, and please, if there's any bankers on the line, I'm not picking on you, they will be happy to be the trustees. I tend to like to have individuals that we know act as trustees if we can trust them with the finances. Banks, I think appropriately, are very conservative in what they will spend, meaning they will spend as little as possible of the trust and conserve as much of it, which it has its place, but sometimes it makes sense to spend a little more. And if you have a trustee that's in tune with the beneficiary of the trust's need, perhaps a local person, a friend, a relative that you can trust, it makes sense. You can also have a guardian, and I didn't mention that, but you can have a guardian of the person. That's the person, if you have minor children, that will take care of your children until they're emancipated, typically age 18. If it's a child with some special needs that perhaps would justify the guardianship lasting longer, that can be provided as well. But the guardian takes care of the person of the child. The trustee takes care of the financial needs of the child. and they can work together. It's not a bad idea to have one person or one group be the guardian and a different person or a different group be the trustee. For example, you may want to have a sibling and their spouse be the trustee of the money, and a different sibling and a different spouse be the guardian of the person that the child lives with. Just another way to do it. The last person that I want to talk about in an estate is the personal representative. And here in Maryland, I love Maryland, but we have to make things difficult and different and confusing. And we changed the name years ago of what everybody thinks is the person who takes care of the estate, from the executor to the personal representative. I have no idea why, but Maryland's got to be different. But the personal representative is the executor. You can have more than one personal representative. Not a terrible idea, can be cumbersome. At least one of your personal representatives must be located in the state of Maryland or reside in the state of Maryland. The reason for that is that if you have to file the estate, the court wants to know that the personal representative is somebody that they can reach out and touch and make sure they get the attention of. And so they want someone in the state of Maryland as personal representatives. You can also have alternates for any of these positions, meaning you can say, my sister is the executor of my estate, my other sister's the second executor, and if neither of them are available, my cousin or my oldest child or whoever you wish can become that. So you can have alternate personal representatives, and although we won't go into it much, if you're going to probate the estate, there's a nominal fee that has to be paid by the personal representative to guarantee their money. And again, the only reason there's a nominal fee, because most wills waive a bond of the personal representative, is the court wants to be guaranteed that the monies that are owed to the court are paid. And so they require a bond so the personal representative doesn't abscond with them. That's the will. That's the document that tells people who gets what upon your passing. It can be very specific. It can be very general. You can just say, I leave everything to my spouse. Or you can say, I leave everything to my spouse except my wedding ring, my gun collection, my antique pocket watches, whatever it is that you want to leave to other people, and make those specific bequests. But that is the document that we all think of. But the other three documents that we should be thinking about, which are equally important, the first is the general power of attorney or power of attorney. These can be general or limited. Usually they are general. So a general power of attorney authorizes some third party to act on your behalf in your absence. Typically, if you are married, you and your spouse have access to most of your accounts together, but you can appoint a spouse as the general power of attorney. You can also appoint another person as your general power of attorney. And again, this is a document that's going to change. When we're young and healthy and we believe that everything's going to go fine, we have less need for a general power of attorney, or so we think, than as we get older. As we get older, we know there's certain changes that are going to happen to our abilities, both physically and mentally, and so we may want to appoint some third party to take care of our finances for us, even while we're alive, and a power of attorney can do that. I think it's good to always have a power of attorney, even if you're younger. And please, I'm not wishing this on anyone. I hope it never happens. But if we're in that serious car accident, which incapacitates us enough that we can't function, but doesn't leave us, but we linger on or we stay alive for a period of time, we may want a person, even if we're 20, 30, 40 years old, to take care of our estate, even at a very young age, our financial estate. And that's where a general power of attorney can come in. The other type of power of attorney is a limited power of attorney, and these are helpful too. If you have, and I hate to talk about it now because none of us are really traveling much, but if you have a big trip planned, you're joining the chamber and you're going to Eastern Europe for a tour, or you're heading to the Mediterranean, or you're going to the South Pacific, and you're going to be out of the country for a number of weeks or a number of months, you may want to appoint a limited power of attorney that appoints some third party with authority to take care of financial transactions for you. And you can be very specific. You can say, I want, you know, Jane Smith to be able to sell any shares of, you know, IBM that I own, if that's necessary, during the 4 weeks that I'm out of the country from September 1st to September 28th. Or you can appoint Jane Smith to have power to sell any stock or any asset that you have during that period, during those 4 weeks. Or you can appoint Jane Smith only if you're not physically able to do it. So as long as they're still able to reach you and communicate with you, and your mind is strong and your body is strong, Jane Smith can't do anything. But if you become incapacitated, then in that case of a disability, Jane Smith can act on your behalf. The other two documents I'm going to move ahead to is the medical power of attorney. This is a document which has grown over the years. The state of Maryland now gives us a form that is fairly exhaustive and takes a lot of work to look at. The medical power of attorney appoints a third person to make medical decisions on our behalf. Again, you can make it a general power for medical decision making or limited to specific instructions. You can, within a medical power of attorney, give guidance. You can say, I don't want to be kept alive by machines. If that's all that's keeping me alive, I ask that my caregivers turn off the machines. Or you can say, I believe, based on personal belief or religious beliefs or any other belief, that we should stay alive absolutely as long as we can, and so I want to keep them on. Medical powers of attorneys address things that you know, perhaps some of us think are impossible or not likely. What if you're pregnant and it's your life or the baby's life? What if you have a limb that your chances of living are markedly better if the limb is removed? You have an injury to your arm or an injury to a leg, and if they cut off the leg, your chances of living go up dramatically. You can leave instructions like that. Medical powers are important because it avoids conflicts among our friends and family if there's a problem. If there's no medical power of attorney and there is no spouse that the courts will look to generally, then the doctors are going to maintain life as best they can for as long as they can, regardless of what our wishes would have been if they could have spoken to us. So by having a medical power of attorney that appoints a third party to make those decisions, your decision making is extended through that person to the extent that you trust them. The last document that I want to talk about is this thing that we call a living will, or I like to refer to as a right to die declaration. It's a very specific document, again, something that's been formalized by the state of Maryland through the legislature in a good way, that says, death is imminent, I'm going to die whether or not I'm kept on the machines or not. And in that event, I want. And it allows you to make a series of choices. You can choose to be kept alive as long as possible, any way possible. Have the machines turned off, but be kept alive with food and water as long as you need it. Or have the machines turned off and have food and water not given at times. That is not as cruel as it sounds. We know that at end of life, typically what the body will do is it will shut down intake and it will expel any excess fluids from its body, and that's a normal process. And so if death is imminent, and that's the condition that a living will applies to, and you decide that you don't want food and water, there's nothing wrong with that. The one caveat that everybody needs to keep in mind is, regardless of whether you want machines, regardless of whether you want food or water, you're going to get any needed medication for pain management to keep you as comfortable as possible. The last thing I want to say about living wills is these are documents that, in some people's view, accelerate or decelerate the rate of dying. And there can be religious considerations that play into that. A number of religions have dictates that say it is wrong to end the life unnecessarily or prematurely, and therefore you should try to stay alive in any capacity as long as possible. And so that's something that you need to think about. It's an individual decision. I can't give you guidance on that. I can tell you the religions that I know of that have mandates, but it's ultimately going to be your decision to make. So those are the basic documents. Why do we need them? Again, if you don't have these documents in place, we're stuck guessing what your wishes were, or in the case of medical documents, medical directives, doctors are going to keep you alive as long as possible, regardless of what the reality is. Now, having said that, the one kicker, and living wills came out roughly about 40 years ago. There was a young lady in New Jersey named Karen Ann Quinlan, many of you may remember her, who was being kept alive solely by machines. And her parents fought a long legal battle to have control over whether those machines should be turned on or should be turned off or left on. They ultimately won it. And the irony of all of that is, after they won it, the machines were removed, and she continued to live for about another 3 years. And so our bodies are going to do what our bodies decide to do. We don't have control over them. And I don't want to go into a discussion of assisted suicide. We're not at that point in this state anyway that I'm aware of. And so we do continue. But I do think, even given that we can't control what our bodies do, it's very helpful for us to direct who gets our assets and what happens to us at end of life decision making. And again, these are not a one-time discussion. I encourage my clients that see me about wills to think about doing it again and again and again. And I don't mean every year, but every 10 years, every 5 years, as conditions change, you want to think about it, because what you do with a will and who gets what will change. And again, going back to my friend who got married and found out that the spouse had left the pension to a child, not in a bad way, not in a mean way, they just forgot, oh, everything was left to the child, because when that was done, it made sense. That's why you want to consider looking at your estate situation at all times. So having said that, I am happy to answer any questions you may have, and I hope there are some.
So there is a question, I think you might have just touched on it. How often should we be reviewing our will? So you kind of had said that, and as our assets and estate evolve, is that one of the triggers? And what are some other of the triggers that you can think of that might want to have us take another look at the will?
Okay, so you look at a will when children mature. As your children become 18, graduate high school, move on to college, graduate college, that's a time. When you have grandchildren, that's another time. If your estate markedly grows, if you have an estate that is a house perhaps of say $350,000 or $400,000, you figure roughly if you have that much in a house, you have half again that much in assets, you maybe have some savings, you have an estate of $600,000 or $700,000. If in 5 or 10 years that grows to $1.5 million or $2 million, that's a significant change that you want to look at. And as we age, we want to look at it. While you're in a viable, working, healthy mode, making money, your estate looks one way. Once you decide to move to a retirement or partial retirement, you ought to think about re-examining what's happening with your assets. Where does the pension go? What happens to the life insurance? Anytime there's a major life change, like the passing of a spouse, you need to look at that again. And so those are the times typically that we would look at it.
Perfect. There is another question from Chris. If there is conflicting language in a living will versus medical POA, does one document supersede the other?
I believe that what you're going to find, that if you are in a living will situation, i.e. you're in an end of life situation, the living will is going to control, where the doctors are going to more often than not look to the living will, because the living will is the direct decision making of us as individuals. The medical power appoints some third party, and yes, there are some directives in the medical power. Now, if the living will was done 15 years ago and the medical power was done last year, they're probably going to look at the medical power. But typically, The living will deals with end of life, meaning within 6 months of death or sooner conditions, and the doctors typically will look to that first unless there's some reason to overrule it, such as it was done 20 years ago and now we have a very specific medical power.
Okay, great. Um, what happens if someone doesn't have a will?
If you don't have a will, what happens is everything in your estate gets inventoried. You file a report with the court, and you have to pay a fee on that, share to the court. And if it's a large enough estate, you actually wind up paying taxes. In addition, you don't get to decide who gets your assets. And so everything's going to go to your closest relatives. If you have children, typically, or spouse, it's going to go to your spouse. If you have children, it's going to go to your children. That gets a little complicated because the spouse has a share that he or she are entitled to select, and then the rest of it goes to the children. But that's why a will is relatively easy. And let me just mention that most attorneys will do a simple will, and by simple will, I mean not a lot of money, for very relatively little money. We're not talking $10,000 here. We're talking under $1,000 to do these. And so it's a good idea to make sure you have a will so that someone can decide who does it. And also, if you have children, who takes care of your children, who takes care of your children's assets.
Okay, so when you go do a will, let's say that we call Bob Frank and say, Bob, we would like to get a will done. Are those power of attorneys included, or are those, do you have to ask for those as well?
Depends on the lawyer. I go over this same sort of speech with everybody that comes to see me. I generally will make sure that everyone has a living will if they want it, and a medical power of attorney. The general power of attorney, the financial power of attorney, is a different creature, and that one you pay something extra for, and the will, of course, is its own document. The fact of the matter is, anytime you go into a medical facility for inpatient or even outpatient treatment, they are supposed to ask you if you have a medical power of attorney or a living will. And in fact, if you don't have either of those, they are supposed to offer you the opportunity to fill one out right there. And I don't know how often that's done, but it is part of the process.
Okay, perfect. If anyone else has any other questions, please post them now, because we are right at 12:30, and that was great timing. So Bob, what amazing information you just gave us. To spend a couple $100 to save our loved ones thousands of dollars, plus fights and headaches and everything else, is well worth it. So we really do appreciate you sharing all of your knowledge with us today. And as you all may know, I do record these. So you will be able to see a recording and be able to share this link. It will be posted within our YouTube channel for Northwest Chamber shortly. Can tell you probably within the next 24 hours. So Bob, I do thank you again. If you have any parting words or any more advice, now is the time.
The parting words or the advice is, everybody ought to do a will, or if you haven't done it recently, have it redone. And the other parting words are, thank you to the Chamber, because they've done a tremendous job this last 6 months in a very difficult time.
Well, it's our pleasure giving as much value as we can with the resources that we have right now at our in our hands. So thanks again, everyone, for joining, and please find this video and share it so Bob's advice can be shared with your loved ones and family members. Okay, everybody, have a great rest of the day, and we will see you next time. Thank you, Bob.
Thank you. Bye-bye now.
Bye.